On behalf of the Bombay City Civil and Sessions Court Bar Association, I welcome our Honorable PJ, Principal Judge Sir, Shri.Anil Subramaniam Sir, who is going to deliver a lecture on the topic of ADR. I welcome him on behalf of the association and I request our President to present a bouquet as a token of respect to Subramaniam Sir. Thank you, sir. Today's speaker, we don't require any further information about him because he is our principal judge and earlier also he was here. And as a bar association, whenever we find any difficulties in the administration of justice or courts, we always go to him directly and whenever possible, he tries to solve all these problems. And also a person having vast knowledge about different kinds of matters, he handled various kinds of matters, delivered judgments in various matters. I will straight away request him to come and take the dais and start today's lecture. Thank you.
Hello, good evening. Sorry for being late 5 minutes, 10 minutes. As you know, there are some other issues also going on. ADR. What can anyone say about ADR? What it is? Alternate dispute resolution? Anything else? Alternate remedy available? Yes. Yes? Chalo sir, काय problem? अच्छा. Yes? This I won't be speaking, you will be speaking. This will be something different. Yes? Arbitration. That is kinds of ADR. What would A stand for? Paralegal services. Yes, that is one of the modes of ADR. What would A stand for? What would you like A to be standing for? A is alternate, A is additional, right? That is what you always love, right? So we start with it. So what I want is something different. I don't want additional or alternate. I want something different, right? Mediation, one of the modes of ADR, it always says that something is different. Correct. Now we will deal with it. What is your main objective as being a member of this justice dispensing system? What is your main aim, objective? Professionally, yes, we may have, as an service oriented guy, I will say, मेरा salary मेरे को मिलना चाहिए. As a professional advocate, you will say I should get my fees. That is always there. That apart, what is as a being part of what do you appreciate that it should be? A person, what should a person get? Solve the dispute, correct? Number one. Court is something. Now consider as an advocate or as a litigant. What do you want? One is that the dispute should be solved. Correct? What would be the second part that you would have? Minimum time. Right? It should be minimum time. Minimum time is, there is a small word for it. We call it as timely justice. Right? Many cases we find that person is injured, he is in hospital, but our MSCT cases take for a long time before after he is discharged, after a couple of years, we pay him the compensation. Right? So is it timely justice? शादी होने के बाद उसको कभी वो बच्चा जब होता है तभी वो पैसा मिलता है. It takes time. Litigation takes time. So are we doing timely justice? What is the main cry every day and now when we consider courts? Are they saying that they are getting timely justice? Are litigations having a period of limitations everywhere? Yes, we have this trial should get completed within 6 months, that trial should get completed within 6 months, this nature of trial should be expeditiously heard. Is it happening practically? No. So are we really dispensing timely justice? Are we achieving the goal that we are really what we became for? Right? Now we have to appreciate that in that aspect of it. Now I shall deal with this in this part in 3 parts. One is like I am an advocate first, I wear a black coat first and then on it on a gown. So I say I was an advocate, I will be an advocate first and then a judge. So we will first consider about an advocate. Correct? Now I always give this example and let us come down to it. Any no problem in English ना? माझं इंग्लिश खराब आहे समजून घ्या फक्त आणि मराठी आलं तर तसं सांगा मराठीत पण परत सांगेन नो डिफिकल्टी हिंदी ऑल्सो बट हिंदी इज बॉम्बई हिंदी सो यू हैव टू लव इट येस अ डॉक्टर करेक्ट इज ही अ प्रोफेशनल करेक्ट डू यू अप्रिशिएट दैट अ डॉक्टर इज अ प्रोफेशनल ही इज एज प्रोफेशनल एज यू आर करेक्ट now you have a headache right now you have a headache what do you do take Canacin, Saradon yes anything different yes have tea put a balm correct now what happens is for 2 to 3 days your headache doesn't go away right it continues it doesn't lessen down it's very or maybe the same client headache wala client aate rehta hai ho sakta hai but otherwise your headache doesn't go away what happens then go which doctor a normal physician okay then again what happens is the physician examines you gives you some drugs or prescribes some medicines and still your headache persists then what happens we go to a specialist. How many of you have gone and now we go down to a specialist? Now let us say I am the unfortunate guy who has something in my brain that has to be removed. Right? कुछ तो भी दिमाग में काला है वो निकालना है तो वो then what would happen? Whom will I go to? A neurosurgeon. Correct? Now how many of you have broken their heads because you have a headache? Or went to a neurosurgeon directly because you have an headache? नहीं मेरा सिर फोड़ दो और पहला निकालो उसमें से फिर मेरा सिर दर्द ठीक हो जाएगा डज इट हैपन दैट वे इट डजंट हैपन दैट वे आई एम पॉइंटिंग इट आउट दिस टू यू देयरफॉर आई सेड द फर्स्ट सेंटेंस दैट हैपन्स इज दैट यू आर प्रोफेशनल्स what is your field of specialty law do you consider law is a very easy concept for any common person to really interpret and understand is it easy for us actually It takes a lot of time. So when we learn law, have you put in some efforts to learn law? Some practice in learning law or being experts in law. Right? Now if that is happening, are we professionals in law? Then are we entitled to treat a headache? No. But we are doing it. We are doing it. Are we not? How many times I have handled many briefs, so don't. I am always saying I am member of this bar, I am member of this advocate community, so don't take it otherwise. But how many times you have seen papers that you know this case is hopeless, but we'll fight it out. We'll work it out. We'll take some dates. We'll try to gain something out of it. हो जाता है कभी-कभी वो खराब केस भी जीत जाता है. No difficulty in it. But how many times does it happen? Quite a few times. How many times do you understand that सामने वाला थोड़ा अच्छा सुनता हो तो ये केस कुछ है नहीं इसमें 2 मिनट में समझ सकता है. I'll give you a small example where you won't be involved. No one will be. BMC cases you file a suit, follow due process of law. There is a judgment on this and I can assure you if that BMC suits, if I take charge of those BMC suits, there is a proper judgment of our Honorable High Court Division Bench, which says that if such suits come, at the inception itself they should be decreed. And on the day of filing first orders, the suit should be decreed and thrown out of the court. Can I pass a decree that you should not follow the law? Can I pass a decree, a court pass a decree that due process of law should not be followed? No. Can the BMC say that they won't follow due process of law? Then what is to be adjudicated? Is the law laid down in BMC? Is law laid down in BMC? What process is to be followed? Act. MC, whatever, इधर क्या बोल कुठला कायदा है? MC Act. It is stated there what procedure is to be followed. So what is the procedure? What is there in it? That is what I am saying. That is the laid down procedure. So breach है तो breach है. खत्म हो गया. Can corporation say that there can be a breach? They can conduct breach. Proceedings in breach of law. Can the court say that this breach can be condoned? No. Simple as that. Then there is a judgment of our Honorable High Court. You can search for it, which says that on the first day itself, such suit should be decided. It should not be kept pending. No need to issue notice. And the suit should be decreed. They don't say dismissed. Right? Now, Fashion Street, because I don't know, we have, because of the malls, we have lost sight of purchasing sabji vagara. I love it. But now we go down to a Fashion Street. How many of you visit Fashion Street? Everyone? You all go? I used to buy my shirts during my practice days. अभी नहीं जाता हूँ, लेकिन practice के दिनों में वहाँ से ही shirt खरीदता था. White shirts बहुत अच्छे मिलते थे वहाँ पे. Right? Now, you go to a Fashion Street, you want to buy a white shirt. There are quite a few shops of white shirts, right? Are there quite a few shops? Right? You go to one shop. You see the shirt. Fixed rates, white shirts, if you go down to those shops, you'll find that fixed rates. White shirts fixed rates रहता है, 2-3 वैरायटी रहता है, 100 रुपया, 200 रुपया, अभी जब भी 50, 60, 120 था, अभी 100 रुपया, 200 रुपया, 300 होगा, मैं गया नहीं बहुत दिन से. Right? It could be. I don't mind going there. I eat pani puri on the roadside tapri. I don't mind it. I am a human being. Why shouldn't I do it? There is some protocol, I don't know why that is there in mind, but I love it. So you go down and you buy a shirt from X person, the first shop that is there. Any reason why you don't buy the shirt from the second shop? Same shirts, same rate. Any reason? You are used to you are looking for a variety. Yeah, but the shirts are same, nearly the same. You will get same grading. It is there. Those same lots are divided by 3 or 4 guys, and they have that same thing. That is psychology. Ajun changla ase, best price. Now you go down to the second shop. Do you really buy in the first shop immediately? You go to the second shop. You may also go to the third shop. Why do you go? Is it now you will get it? Is it additional or alternate? Is it additional just because it is additional or alternate? Think about it. It's neither additional nor alternate. Choice. What do you get by choice? If there is choice, what do you get? Option. And what option? Is it a good option or a bad option? What do you search for? A good option, a better option, a satisfactory option, right? An appropriate option, right? Now someone might want a Chinese collar, someone might want a thoda sa self design wala, someone might want a different tie collar wala, someone wants a button on his collar, someone wants white shirt with white t-shirt buttons, someone wants white shirt with transparent buttons. Very many people have their own choices, right? Now if I just say, वो first shop में नहीं जाना है, second shop में जाना है, would you like it directly going to the second shop? Just because I am referring it, you like it. But do you go in as an दिल से जाएंगे क्या first shop छोड़ के? We'll go to the first one also. Correct? Now think of it in this manner. People, how many years in litigation people spend? 15, 20, कितने जन्म, 2 जन्म, 3 जन्म भी है litigation वाले? Yes, I am having a suit of 1975 if I am not mistaken in this court. Right? So are people believing in this system of court? Correct? Do they come to this court with the belief that they will get justice? So for them what is appropriate? For them what is appropriate for a court? Correct? Now I tell them they come down to my court. Now this I am related to court because you are all in the court, therefore otherwise I may not relate it to the court. But say to your office also you can say that. They come down to your court or your office and they say मेरे को कोर्ट में जाना है because I consider it appropriate. तुम बोलते हो नहीं भैया एक काम करो वो कोर्ट में मत जाओ वो बाजू वाले रूम में अल्टरनेट सिस्टम है जाओ उधर. How much people will believe in it? So if it is alternate or additional, do you think people will like it or believe in it? No one will do it. You will never do it. You will never do it by heart. By heart, I mean, you will never participate in it. वो बोला करके जाके आएंगे मीडिएशन में जैसे घूम के आते हैं. Right? That is what is happening. I'm not. It's a practical thing. I'm not. Nothing is out of what context. Nothing is out of facts. This is out of practice and this is out of experience that I'm speaking about. Only if an remedy is appropriate to you, only if you get the shirt of your choice, you will go to a particular shop. If it is not of your choice, you will not go to that shop. Now, if you want to show a person that this is to be happening, you have to show not it is an additional, not it is an alternate. अभी एडिशनल बोला तो आपके सिस्टम पे भरोसा है क्या? आपके प्रोफेशनलिज्म पे भरोसा है क्या? See, there are many doubts. As a part of this system, I am a responsible person speaking. There are many doubts. So, is a person believe? Are you disbelieving your own system when you say alternate जाओ, यहाँ मत जाओ, वहाँ जाओ, ये रास्ता मत करो, वो रास्ता पकड़ो? It is something different that is happening. And therefore, what you have to calculate is on what is appropriateness. It is not additional, it is not alternate. So, always remember ADR should be appropriate. And that is, if you read AFCONS, it says it should be an appropriate alternate dispute remedy. It does not only qualify it as additional or alternate. It should be appropriate. And that is more important when you go for ADR. Understand this. RTO के पहले पुलिस रहते थे. Do you remember पुलिस? वो क्या करते थे? क्या करते थे अगर वायलेट किया तो? चला मैंने वो पावती रिसीट निकाल के फाड़ के दे. आज क्या होता है? डायरेक्ट घर पे मोबाइल पे आ जाता है. Now remember this, we are also facing technological issues. There are, in China, there are judges, automated judges now, who decide cases based on AI. If you read AI and judicial system, you will find in China there are judges who are deciding, computers who are deciding cases automatically. You feed in the necessary details, it comes out. Do you know eBay? How many of you know eBay? Amazon? Yes, Amazon is newer version, eBay is the older version. They decide by ADR more than millions of cases they have decided by ADR. They have an EEDR, electronic ADR system. A computer asks you what is your difficulty? Sir, I didn't get the goods. Okay, when did you book it? It goes back to the record and gets back to the seller and says, did you send these goods? He says, yes, I sent these goods. Where is the challan? This is done automatically. No human interference. If that vendor is unable to give within 3 days or 2 days, whatever is the appropriate time, a proof satisfactory to that system that the goods have been sent, the money is not paid to the vendor, but it is refunded back to the seller. Think of it, a machine is taking up what job? Are there suits of this nature in your courts? Yes. Goods have been sent, not delivered. Who is doing the job there? A computer who has no brains, who is doing nothing. So think AI is going to be a huge thing. How many of you have tried a chatbot, ChatGPT? One. What did you try? Only normal letter. Oh. Try for, yes. I'm telling you, in China there are robots to decide matters. Forget advocacy. Now go down. You will get few options for Chat GPT.
Sir, it seems in America, the lawyers are using artificial intelligence
To draft.
to
Predict.
how a judge will give a
That is always there.
on his past decision and his
You
way
get
of
it.
thinking.
You get it on India also. Manupatra gives you what are the trends.
His way of thinking, that is my
Manupatra gives you the trends. So try to find out. People are using it. The other day in one of my arguments, they came up with bunch of judgments, which sir, these are your judgments, and you have held this point in this way, so please hold it in this way. Right? That is how it is. That is what AI will do. It's going to challenge your professional skills. There are many challenges to your profession. Understand this concept. There is second part of it. The third part, with due respect to the bar, firstly, it's not. This was a part of this. I have not related it, so don't consider it in that sense of it. Is the infrastructure? Forget this code, city civil code. Anywhere you go in India, how many places do you find that there is proper infrastructure? Very poor. How many places do you feel that we can put up courts immediately? That if I have 100 more cases, I should put a new judge so I can give timely justice. Now, when I received a letter from this bar that there are 9,000 plus members in this association, I was shocked. I got a rude shock and it really turned my mind somewhere else. Can my courts provide you with subsistence? Can my existing courts provide you with subsistence? I'm thinking, professional, you don't do free work. We do work for a living. Are we not? How many of us do it for free? Very few cases we may do it, certainly. But our aim is to fill our stomach. Somewhere there, that aim is there. That object is firstly, secondly, thirdly, depends on a person. But that objective is there. You didn't come into this profession just to do pro bono, and that is something different. I don't know how many of you have come, but there are few persons who do it. There may not be, but most of us we come down to earn. If I can't provide you with work, will you have some source of money? Right? Therefore, ADR will be required. Now, is ADR out of the system or out of legal bounds? No. ADR has to follow the same rules. Is Contract Act different in arbitration? Is Contract Act different in mediation? Is Contract Act different in conciliation? Is Contract Act different in Lok Adalats? Is it exempted? Nothing is exempted. The basic acts of work governing the parties is the same. The rules of procedure may change. Rules of procedure don't govern rights of the parties. So remember this, that this is a source or a measure of your betterment. If you choose a role of ADR, it will be for your prosperity as a profession. I don't have few of my friends who come down and they are trainers and they are mediators. If you consider their earnings, I was shocked that one of the trainers told me for 2 hours they charge around 30 to 40,000 rupees of mediation. Minimum. That is for otherwise they are charging more also. If you they will tell you what are the approved rates of mediation in PIMS cases, commercial suits. There is a standard rate. It's quite substantial. You can consider it as a source of income. You can consider it as a source of having a different field altogether. Litigation is good. No doubt about it. I love litigation. I'm dead. I don't go to appellate courts. I don't like appellate courts. Trials are my life. Yes, but you can certainly consider this as an ADR. It's an interesting field. Now let us consider about the litigants. First part is advocates. Do you consider ADR as an appropriate part? Can you give timely justice with ADR? We'll see that. Now as litigants, how do you feel that if I don't get litigation, what happens? Are your clients happy? Are your clients happy that you cannot give them timely justice? How many times clients come? कितने बार आना है कोर्ट में? Are the clients happy with the system at least? No one. No one. They are happy with nothing. So are the litigants? Are we serving the litigants in that manner? Right? So I think the litigants are also not happy. Now come down to the judges. Okay, now I can come on this side safely. Do you think judges are stressed out because of number of matters on the docket?
Yes.
Do you observe that?
Yes.
Do you think judges can really work out your matters properly because of huge number of matters in the docket? No. Now, how many matters many a times I feel that why should this matter be argued upon? But it is argued upon, and quite for a long time. It happens. I'm not saying, and I'm not blaming advocacy, or it is everyone's right to be heard. And in my court, at least I try to do that. Everyone has their own perspective of looking at a matter. My perspective is different. His perspective will be different. His perspective will be different. Therefore, there is an advocate on both sides. So I appreciate that. It's not a derogatory part of it. It's my perspective that this matter should not go on for that period. But as a judge, I am burdened. As a litigant, I am burdened. As an advocate, I am burdened. And there is a reason for it, that this system has its own set of rules. A judicial system or a court system has its own set of rules. Now again we go back to the neurosurgeon. Correct? Remember a neurosurgeon. How many of you could directly enter the office of the theatre of a neurosurgeon? Operation theatre. जा सकते थे? And about a physician, a medical shop, no difficulty. But even physician, you have to ask the counter, then go in, ask the doctor. Yes, neurosurgeon. Right, correct. Now we can go to the clinic, right? Now, therefore, you will have to understand that if you see in pictures, a neurosurgeon has a very complex machinery. He has a microscope, he has a robot, he has a computer, he has this, that, everything. Right? Complicated, because it's a complicated professional surgery that is required to be done. But if you go to a doctor, physician, and he wants to suture it, he will just put on a glove. Now, abhi bhi glove पहनने लगे, पहले वो भी नहीं पहनते थे. He will put on a glove, cut it, use a needle and stitch you up. A simple procedure. That is what I believe is happening here. We have taken a small case of suturing into the neurosurgeon's theatre. What is happening is, for that taking a small चार टाके घालायला जे काय वेळ करायला लागतं, त्याच्यासाठी ते न्यूरोसर्जरी करायला लागली. And we are going into that process of looking into the microscope, going into the procedures of evidence, going into the procedure of CPC, going into the details of various things, which is not required for that matter. It's a simple matter. I'll give you a small example and then we'll again discuss. Two brothers, correct? Rich, very rich. गांव के लोग रहते हैं, तो पटेल या पाटिल बोलेंगे या पटेल बोलेंगे या whatever it is, राव बोलेंगे, whatever it is. Rich people, very rich. So the father, what he did was, he was very family oriented. So he got a very famous painter, like I don't know, any painter, there's a JJ school, but I'm very weak at paintings. So you can say any painter, whoever is very famous painter, right, in India. Huh? Dhurandhar. So he says Dhurandhar. We say Raja Ravi Verma, I think Ravi Verma painter होते क्या? Correct? So, whoever it was, so the serious, very rich, famous painter. And what he did was, he displayed or he stated, described what his ancestors looked like to that painter. And what that painter did, he made a huge poster showing around 6 to 7 of his ancestors in that photograph, in that poster, painting. So he had 5 or 7 his ancestors, including himself and his children in that painting. Correct? Got it? 5 पिढ्यांचे फोटो त्या फोटोत त्यांनी लावून ठेवले पोस्टरमध्ये. पार्टिशन सूट आला, 2 मुलं म्हटले की पार्टिशन सूट यायलाच पाहिजे ना. काय निकाल द्या? Rest all they have agreed. All properties, all immovable properties, everything they settled. How will you decide? How will the court decide? Cut the painting into
Give the offer.
half.
No, give the offer.
Give offer. त्या किंमत काय काढणार त्याला? काय किंमत राहणार आहे? माझे फोटो कोण बघणार आहे? माझ्या घरच्यांना माझ्या फोटोची किंमत, बाकीच्यांना कोणाला किंमत आहे? Now you get it, what the court can decide and how the mediation or any other process can decide. Now think in some different manner how it can be decided. Why was that photograph made for? It was a remembrance of his family, so that his family is remembered for a long time. How can a family be remembered in future?
Memories, photos.
And how do we recognize? Do you have any other instances of family being remembered? How do you have any now?
There's sound recordings.
For sound, वो अभी आ गया. But if I want my family to be recognized for eternity, what would I do? Photograph is something. He has already prepared a portrait. Statue. Then he has made a portrait. Now that portrait is gone. Can you think of? See, they have a lot of money. What do people with more money do generally? Make a trust. What does a trust do? Do charitable work. And what charitable work it can be like schools, lectures, right? Education, schools, hospitals. So that name of that family will be remembered. And where will the poster will be there? In the trust office. Won't be better?
Yes.
Did you get any of this solution in any of the courts? This is not possible. I should not and I cannot get this suit in the court. Now I'll give Sarambhaka Sahib commercial suits मध्ये आहेत म्हणून मला माहिती आहे कारण ते नेहमी त्रास देतात. तर नाही, all civil practitioners, a simple suit. There was a wholesaler and a retailer. The wholesaler supplies electronic goods का रहता है ना, वो कुछ बेचता है, तो बम्बई में बहुत चलता है. तो wholesaler, what does a wholesaler do? He supplies goods to the retailer. It so happens that they are doing business for quite some time, 5-6 years, continuous business, no default. But for last 6 months, पैसा लटक गया. He is not paying. The retailer is not paying. फिर wholesaler क्या करता है? See, सप्लाई बंद करता है. नेक्स्ट नोटिस देता है. नेक्स्ट कोर्ट में जाता है. नेक्स्ट समरी सूट. नहीं, समरी सूट नहीं. कुठला सूट? कमर्शियल सूट. Yes, next.
Mediation.
Next, mediation. Next, what would be the final outcome? What would be the final option in the suit? Decree? Suit? Yes, sir. They use muscle power, right, sir? That's right. That will come down to the last part. I'll get back to you. You remind me if I end it without referring to muscle power. Yes. Evidence. And what would be the order? Final order? Suit is decreed with
Cost.
Correct? 25%, 10%, 12%, whatever it is. Now, if I come down to settlement, what if the parties decide to compromise? What would be the solution? Leave the interest amount. Yes, one option. Any other option? Settle with it. That's what she said. Leave the interest amount. Anything else? Any other options you can tell? Part payment, so installment payments.
They will have better terms if they want to continue.
Yes, continue. So future have business, give installments. Can you think of partnership? Think of it. Now think of it. Now think of it. It's possible. It is possible. Yes, sir. It can be lesser amount. It may be principal amount lesser than principal amount. But think of it as a partnership. Can any court decree a partnership in such a suit? Can any person think that there is partnership in such a suit? It is only ADR. If I show why is ADR material, is ADR not only things, some ADRs, there are 4 ADRs and I will deal with them. Lok Adalat, court settlements are 2 ADRs and there will be 2 parts, is arbitration and mediation. So I'll leave conciliation is something different. Arbitration has now changed its scope and it has nearly become litigation. So I would even leave that aside, but you can decide arbitration as a better scope of ADR where there are complex issues or where there are issues of science or like architecture, civil engineering or something like that, which is not in our parlance, specialized subject. So arbitration is much better. So you will file arbitration in civil works. It's easier. An engineer is appointed. I don't have to tell engineer that this structure should be of 6. एक ईट का कितना 9 इंच होता है क्या 1 फुट होता है कितना किसको मालूम है what is the length of a brick 9 inches or 1 foot
9 inches.
no see we start from there but and civil engineer you don't have to explain उसको बोलेगा 1 feet एक ईट की दीवार है he knows it's a 9 inch wall he doesn't have to think what is the wall he doesn't have to know what is material is to be used everything is standardized for him गिट्टी कितने इंच की है वो आपने बोलेंगे तो गिट्टी यानी थिकनेस कैसा करना है वो विड्थ कैसा करना है वो एक पत्थर आता है उसका चौड़ाई कितना है क्या लंबाई कितना सो ऑल दोस थिंग्स एक्सपर्ट इज मोर better person to decide. In that cases, arbitration is certainly a good option because that expert knowledge you don't have to bring into it. So arbitration serves that suits very well where there are some expertise or accounting disputes or those matters. The best, I am a very strong propagator, you may agree, you may not agree, but for me, I consider mediation is a very beautiful concept of ADR. Why is mediation better? There is one part of, first part of it is, advocates are entitled to attend mediation. They form, in my view, and I always have taken assistance of advocates, and मेरे को मालूम है मैंने एडवोकेट का दिमाग बदल गया तो पार्टी का दिमाग बदल रहा है. तो मेरा एक आंख एडवोकेट के पास रहता है, क्लाइंट के पास एक आंख रहता है. But I always try to do it that way. But why is ADR good? Mediation is good concept of ADR. Firstly, that it listens to the parties. Second part is it doesn't restrict to the suit involved. Third part and the most important part is whatever option it has, whatever option the party has, a party has a chance to evaluate and take a reasoned or known decision. It's a known decision of the party. Understand this? It's a reasoned, known decision decided by the party for himself. And how does he decide it? By knowing pros and cons of whatever decision is to be taken. That is the work of a mediator. A mediator उसका दिमाग उसका ये कर देता है. He tries to work with his brain and explains to him what his option is. What his option is, he explains to him what are the pros of that option, what are the cons of the option. And then he helps him decide. In mediation, a mediator never decides. So understand this. Therefore, once you have that option generation, now if I decide I have to do this, how much chances are it that I would breach it? If I decide that I have to come to this office and do it, then how much period would it, what is the chance of I defaulting? Less. So understand that is the basic, and how much is the chance of I defaulting when I am taking a decision which is based on my own reasoning and my own understanding of pros and cons. How much? Very less. So therefore mediation is a good thing, because mediation does all this. Mediation not only lets the parties speak for them, mediation does not lets the parties to speak beyond the terms of the dispute. Mediation lets the party create options. Mediation lets the party assess the options. And the entire thing is closed down in a shell of confidentiality. So nothing goes out. Nothing goes out in mediation. What goes out is only whether if the matter is settled, the terms of settlement. If the matter is not settled, that the matter is not settled. Nothing. Why it is not settled, no one is going to say why it is not settled. Only in commercial suits, non-participation is an issue. Now, once we come down to non-participation, I want to point out that more than 80% of the cases in commercial suits, parties don't opt for mediation or don't participate in the mediation process, even though if it is mandatory. Why do you feel it is so? And I'll point out that therefore I said the A is very important. A stands for Anil and A stands for appropriateness. So Anil is telling you appropriateness of ADR. Right? So remember this, parties don't participate there because they don't know the appropriateness of this mediation process. As soon as he can vouch for it, as soon as they come to the court, they meet the other side lawyer, they are asked to file a WS, they say settle kar denge kya. If they had come beforehand, it would have been much easier and faster for them for settlement. Maybe the relations would have come together. Right? So understand this concept that you have to explain, as members of the bar, you have to explain that this is an appropriate process. It's not something we are trying to shun away or go away from the judicial process. It is good for your case. Now if someone comes with a case that what is the interpretation of X provision, I won't ask him to go down to mediation. I won't ask him to go down to arbitration. I would ask him to go down to the court. Right? I will ask him to go down to the court. If someone says this road, main road जो है, ये road बंद करना चाहिए because the court is here, I will not ask him to go down to mediation for that. किससे mediation करना है? No one is there. It's public right. There the courts only can decide what is right or what is wrong. So there are n number of disputes, there will be n number of matters where advocacy will be required. So don't worry that your advocacy will end. This is something, a branch of advocacy that has been developed, which has very sweet fruits. Understand this, if you are giving an advocate who gives timely justice, will be the most sought for advocate hereinafter. ये एडवोकेट के पास गया, ये मैटर नहीं उसने चलाया और ये मेरे को 2 महीने में मोकला कर दिया. He will be the most sought for. Now, gone are earlier days, yes, we used to go on with our matters, we used to go on. Now, everything has changed. People are not ready to wait. People don't have time to wait. Everything is instant noodles. Maggi खाओ. किसी को बिरयानी बनाने के 2 घंटा, वो 24 घंटा लगता है बिरयानी. वो कोई पिक्चर इसमें बताया था, some palace, it takes 24 hours to make a biryani. No one has that time. They want it instant, they want it fast. Then how will you give them fast? And if you are not able to give them fast, will you satisfy your clients? You have to think about it. I have to think about it. My system is at stake. Understand this. ADR is appropriate resolution. Inform this, adopt it, learn the processes of ADR. It's a very beautiful field of a new scope or a new field for your own betterment and for your expansion of legal profession. Courts will be there. Courts won't go away anywhere. But this is where we can have it. Is there any national cause in it? And I certainly believe yes, we are doing nation a duty by agreeing to ADR. If parties are fighting for a long time, it creates unrest, distrust in society. It escalates into some disputes. It brings about lessons learned. Why commercial courts came down? Commercial courts because they want a faster remedy. So everything changes. why we rank very low on the national index, in the international index of business. We want to improve that. Therefore, we brought. Most of you are quite. I started around 32 years of my practice, 31 years of my practice, 31 plus 1 year before that, 32. So I'm in course for 32 years. I've seen we had suits going, I don't know in Bombay, I don't know city civil, but in Pune, we had suits going into around 3,000, 4,000, 5,000. Now we barely have 300, 400, 500. Has the litigation gone? No, the litigation has been diverted. It has gone to DRT, it has gone to Consumer Forum, it has gone to LCLT. A new field has been developed. And we can't divest now more from the civil courts. We can't divest, have more specialized schemes. What we want is you supporting ADR. What I want is you participating in ADR. Right? Any difficulty or any doubt in ADR? Because this is, I'm only on ADR, I'm not on mediation or explaining mediation.
So the litigants have some, so thing is that mediation, there's also costs which the litigants have to incur. The costs are something which they say that when we are, if eventually we have to pay court fees, then fees, that cost factor is also a prohibiting factor from the litigants.
If mediation is there, then there is a settlement. If settlement is there is possibility of refund of court fee.
So they feel what
That is what, therefore I said, you have to show appropriateness. You do it by settlement, you get your court fees back.
if not, then the
एक शर्ट के ऊपर दूसरा शर्ट फ्री मिल रहा है. Yes sir. हाँ जी बोलिए. ये जरूरी नहीं है. मैं बोलता हूँ मेरे पास 4127 के परसों के मैटर में जो सेटल प्रिंसिपल ऑफ लॉ है 40 जजमेंट दिए एक ने. मैं वो बोल रहा हूँ वो अगर 40 जजमेंट में देखा जाए तो ये पर्सनल होगा. इट इज नो वन कैन आई कैन नॉट गो इन बियॉन्ड द प्रेसिडेंट. इफ देयर इज अ जजमेंट ऑन अ पॉइंट इट हैज टू बी डिस्टिंग्विश्ड. इफ इट इज डिस्टिंग्विश्ड यू हैव टू एक्सेप्ट इट एज जुडिशियल डिस्क्रिप्शन.
Sir, but what happens is, if on a point there are Supreme Court judges, there are decisions for and against, and many times, sir, for example, one issue like nominee versus the legal error. So now there are n number of judgments this side and the n number of.
There is only one judgment and one trend in that. That nominee is only a caretaker and a trust holder. Simple as that. Simple as that. No, that came after so many years, but that's a settled principle. It's a settled law. एक मिनट त्यांचा प्रश्न संपून दे. येस आगे बोलिए. ये देखो एडीआर में आप बोल सकते हो झूठा है करके. एडीआर में आप बोल सकते हो ये लिटिगेशन झूठा है. कोई ज़बरदस्ती नहीं है कि कॉम्प्रोमाइज़ करे. कोई ज़बरदस्ती नहीं है कि सेटलमेंट करे. अगर झूठा है झूठा है. कोई सपोर्ट नहीं करता है झूठेपन को. कोई सपोर्ट नहीं करता है. और कोई मेरे ख्याल से इट विल बी रियली मिनिस्क्यूल दैट एक झूठा क्लेम कोई एक्सेप्ट करे कि मेरा झूठा क्लेम है फिर भी भैया मैं पैसा दे रहा हूँ मैं जा रहा हूँ. बताइए मेरे को कितने केसेस है. या तो सही क्लेम में पैसा लग रहा है 20-20 साल झगड़ते हैं. कोई नहीं होता है एडीआर में. नहीं होता है एडीआर में. फ्रीली बात होती है. आप डिसाइड करेंगे तो होगा, नहीं होगा तो नहीं. अगर मैं बोलूँ आपको ये लो जी सर आपको 1000 रुपया है तो आप ले लेंगे. ले लेंगे कि नहीं लेंगे? नहीं नहीं, मैं बोल रहा हूँ, आप ले लेंगे क्या नहीं ले लेंगे? ले लूंगा, यही एडीआर है। अगर वो देने वाला राजी है, लेने वाला राजी है, तो काजी क्या करे? दैट इज एडीआर। उसको उसकी मर्जी है भैया। क्लाइंट अगर चाहता है ये ऐसे सेटल हो गए तो वो सेटल करे।
I think his third party rights may be affected if someone enter into the.
That is something different. Third party has his own remedy. क्या चीज? एक just केसेस एडीआरनी नाही होत. एडीआरनी केसेस संपतात. तेच आम्हाला का जात नाही, कारण त्यांना असं सांगितलं जातं ॲडिशनल किंवा अल्टरनेट आहे. त्यांना ॲप्रोप्रिएट हे सांगता येत नाही. ह्याला सांगता येत नाही की बाबा तू फायदा घेतलायस, या गोष्टीचा तू फायदा घेतलायस, पण आता हे कुठेतरी थांबलं पाहिजे. अजून तोटा तुला व्हायला नको. उद्या 10,000 रुपये द्यायच्याऐवजी 2,000 रुपये देऊन संपव. ॲप्रोप्रिएटली सोडत आहे हा आपण सांगत नाही, त्यामुळे प्रॉब्लेम होतो. सगळीकडे ॲप्रोप्रिएटनेस सगळ्यांना सांगितलं जात नाही. आज 90% प्रॉब्लेम आहे की आपण ॲडिशनल आणि अल्टरनेट पकडतोय. म्हणून मी पहिला प्रश्न टाकला की इट इज नॉट ॲडिशनल, इट इज नॉट अल्टरनेट, इट इज ॲप्रोप्रिएट. ते तुम्हाला ॲप्रोप्रिएटनेस दाखवाल. तुम्हाला शर्ट विकत घेताना तुम्ही बघता ना, तीच पॉलिसी वापरायची. शर्ट तुला कसा चांगला दिसतो, मीडिएशन म्हणून नाही. कुठल्याही एडीआरला टाकताना ॲप्रोप्रिएटनेस नाही दाखवलं तर तुम्हाला माणूस घेणार नाही. जोपर्यंत मला फायदा नाही आहे त्याच्यात, मला त्याच्यात चांगलं मिळणार असं वाटत नाही, तोपर्यंत कधीही एडीआर कोणी ॲक्सेप्ट करणार. सर जी लास्ट. त्याला वेगळा घ्यायला लागेल. मी आज फक्त एडीआरसाठी गेलो. एडीआरसाठी आपण परत एक घेऊ शेड्यूल. एडीआरसाठी आपण वेकेशन नंतर परत लेक्चर सिरीज आहे, त्याला आपण प्रत्येक एक एक लेक्चर घेऊ. एनी अदर थिंग? Thank you very much. I am grateful for the bar. It's certainly an honor to be part of this Parekh lecture series, and I am really grateful to all of them for giving a forum for this great thing. Thank you very much.
Thank you, sir. Now I request our president to present our memento to our today's speaker, Shri Subramaniam, sir. हो साहेब क्या मोमेंटो दे. Thanks a lot, sir. Actually, as sir was guide, he was actually so many things to be done because he has to look after 22nd April's deadline. But already he has committed, so he came today from taking time from his schedule. Thank you very much, sir. Thank you, Dias, and thank you, my dear colleagues, because you also are a part of this lecture series, which makes it very effective. Thank you very much. Please have a cup of tea.